So basically, let's continue with where we stopped yesterday. We were discussing directive principles and we had seen the nature of directive principles. We had also seen how directive principles are the provisions of the constitution which has a mandate for creating a welfare state. We had also seen what are the natures of what is the nature of directive principles, how it is not enforceable, how it has the objective of establishing social as well as economic democracy. We had also seen how it is different from fundamental rights, and we had also discussed how the directive principles, the nature of directive principles and what is its relationship with fundamental rights, how this relationship has evolved, how initially the Supreme Court in the Champakam Dorai Rajan case had this idea or took a literal view of directive principles and Article 37 of the Constitution, which talks about it not being enforceable, whereas fundamental rights are enforceable rights, and that is the reason why fundamental rights were considered to be they were considered to be the overriding directive principles. How since 1957 there has been a change of view in the Supreme Court, how the Supreme Court gives theory of harmonization, and how the Supreme Court says that yes, despite the fact that Article 37 declares it to be non-enforceable and fundamental rights are enforceable, but they are complementary in nature, they are not contradictory in nature, and both of them have an objective of establishing social, economic as well as political democracy, which is a part of our preamble. The objective is not about solely establishing political democracy and not social and economic democracy. Taking this into account, the Supreme Court comes up with this theory of harmonization, making the judiciary itself responsible for interpreting directive principles in such a manner that they do not contradict fundamental rights. Then we have also seen the constitutional amendments. To be very specific, we have gone through the 25th constitutional amendment, I think it was. The 25th constitutional amendment, which introduced Article 31C to the Constitution, and Article 31C specifically said that any steps that were taken by the legislature or the executive to implement Article 39 clause B and Article 39 clause C, which talks about an egalitarian social order, and to establish it, when any step has been taken by the legislature, the law will not be declared as unconstitutional or void, specifically on the grounds that it contradicts Article 14, Article 19 and Article 31 of the Constitution. How in the Keshav Nanda Bharti case, the Supreme Court upheld the constitutional validity of this amendment, and how in the 42nd Constitutional Amendment Act, the fundamental rights, it was considered that any directive principles, if they are to be implemented in that process, if it contradicts Article 14, 19 and 31 of the Constitution, it will not be declared as unconstitutional. The 44th Constitutional Amendment Act removed Article 31 of the Constitution, which guaranteed us the right to property. It was removed from the Constitution. Similarly, in the Minerva Mills case, the Supreme Court held that this disturbs the balance between the 42nd Constitutional Amendment, the changes that 42nd Constitutional Amendment makes in Article 31C, it disturbs the balance between Part 3 and Part 4 of the Constitution, and hence that amendment under Article 31C was held to be unconstitutional. So for today, if you look at the contemporary idea is that if there is a law passed to give effect to Article 39 clause B and clause C, even if it is contradictory of Article 14 and 19 of the Constitution, it is still considered to be valid. It is not declared to be unconstitutional. So the current relationship is this. Then we started with our discussion on directive principles itself, and we started with the first directive principle that is mentioned under Article 44 of the Constitution, which says that the state shall endeavor to provide all of its citizens a uniform civil code. Yesterday we had also seen what is meant by this idea of civil code. As I said, whenever we talk about civil laws, laws are basically of two types. There are certain laws which deals with our relations in public sphere, and there are certain laws which deals with our relation in private sphere. When we talk about a uniform civil code is something that deals with personal laws, laws such as divorce, laws such as marriage, laws such as adoption rights, maintenance, inheritance rights. These are some personal laws, and uniform civil code deals with this. How we had also seen that in the Constituent Assembly there was a debate about whether we should adopt it as a part of our constitution or not, and there were two reasons that were basically given here. The reasons were that first of all, if we allow for a uniform civil code, it will be a violation of our fundamental right, and second, it would result into tyranny against the minorities. So tyranny of the majority against the minorities. How K.M. Munshi was of the opinion that this is not true. What is it? I am coming to it. And post that we adopted Article 44 as a part of our constitution under Directive Principles. Similarly, post that, how we have also seen the political developments that led to the formation of a Hindu code. Not a uniform civil code, rather a Hindu code. I had also defined what is the meaning of the term Hinduism, legal term, legally what it means. Then we had moved into the next idea, that is the Shah Bano case, how the Supreme Court, came up with a decision in the Shah Bano case, and how politically this decision was made use of, and there was a law that was enacted by the Parliament of India. The Rajiv Gandhi government enacted a law depriving the guarantee or the protection that was given to the Muslim women under the Shah Bano case, that was later on deprived by the law that was enacted by the Rajiv Gandhi government. Post that, there has been, because of the kind of politically it was a very sensitive idea, and that was the reason why no other political parties talked about a uniform civil code until very recently in 2014. In 2014, the BJP, while declaring its political manifesto, it declared that one of its political objective, if they come to power, would be the establishment of and the adoption of a uniform civil code. Though they were not able to do that in the last 5 years of their government, but again in 2019, the general elections, they promised the same idea, and various ministers have been talking about a uniform civil code. In fact, in a very recent interview, even our Home Minister along with our Prime Minister said that we are in a process, we will definitely try to achieve this. So this is the base. These are the political developments that we see here. Now we come to the effective debate when it comes to the uniform civil code. Clear? So when we talk about a civil code, what does this mean? See, making this statement that in India we do not have a uniform civil code is not completely correct. Why? Because we have a partial uniform civil code. Partially it is applicable. Why? Because whenever it comes to any matters that deals with public civil code, that means our interactions with the society, not just in our family, our interactions with the society, for that we have a uniform civil code. What we do not have is a uniform personal code. What we do not have is a uniform personal code which deals with things such as marriage, divorce, adoption, inheritance and maintenance rights. When it comes to these rights, now in these rights there are certain problems. Now, first of all, let's go into the Constituent Assembly debate and let's see what the Constituent Assembly had to say and why, despite the opposition, some members opposing the idea of presence of this term uniform civil code in our constitution, still it was adopted. If we look at the debates of the Constituent Assembly, you would find that the Constituent Assembly specifically mentioned two concerns why it was not considered appropriate for the Constitution to declare, or the Constitution to have this provision of a uniform civil code. As I said, the first provision was dealing with this idea of a violation of religion or freedom of religion. Now, on the basis of our previous discussions, can we say adoption of a uniform civil code is a violation of? Is it a violation of the right to religion or the right to freedom of religion that we have under Article 25 of the Constitution? Will the adoption of a uniform civil code, will it be a violation of it? Yes or no? These are not essential practices for what? For any religion. Yes, absolutely correct. Uniform civil code, adoption of a uniform personal civil code can never be considered as a violation of our fundamental rights. Why is it not considered as a violation of our fundamental rights? First of all, because whenever we talk about right to practice of religion that we have, right to practice of religion, first of all, based on our previous discussions, we know it is not an absolute right and it is subject to provisions. Like Article 25 explicitly mentions provisions of decency, morality and public order. Secondly, the second provision that it says, or the second exception that it mentions here, or restriction that is mentioned, is subject to other provisions of the part, which means some other rights that we enjoy as a part of our fundamental rights. Those rights, if it is contradictory, if right to religion is contradictory to those rights, in that case religion will always be considered, this fundamental right will be subject to that particular right. And we have right to equality. Now, how it affects here, I'll come to that. However, as a part of our discussion, we also know that the Supreme Court has previously, in other decisions also has said that when we talk about religion and religious practices, it is the court which will decide what are the practices that are integral to a religion and what are the practices that are not integral to a religion. Any practice that is integral to a religion, it is there where the state cannot interfere. However, if there is a practice that is not considered integral to a religion, that means the existence of that religion is not dependent upon those practices, in that case they are to be declared as secular activities. They are not something that is integral to a religion, they are not the part of religion, and hence they are considered to be secular activities. And when they are considered to be secular activities, the state has the right to make laws on it. The state is absolutely, the state has a right to make laws on it. So, can we consider marriage or the mechanism or the procedure that guides marriage, can it be considered as an integral part of a religion? No, it cannot. It cannot. So an individual, like, we talk about, if we talk about personal laws in India, personal laws in India are almost similar. Now, personal laws in India are almost uniform except for the followers of Islam. Those individuals who are following in Islam, for them we implement, in India, a partial implementation of the Sharia law is applicable, the Shariat, that is called as the Shariat. So partial implementation of that is, it is permitted. Otherwise, what you find is for other religions that are in existence, for those religions or for those individuals practicing those religion, there is a uniform personal code that is in existence. There is a uniform personal code that is in existence. So whenever we talk about lack of a uniform civil code, it is always considered to be, whenever we talk about why the state should take that up, it will always be considered to be against a particular religion, and that is the reason why it said, it was said that it will lead to tyranny of the majority over the minorities, because this is what is it is generally considered to be. But the fact is that this is not true. Why? Because whenever we talk about the practice of Islam, if you go by what the court has to say, the court has to say that all practices that are taken up by a religious community cannot be considered that it is an integral, it is a practice that is integral to that particular religion. So how can we say that the procedure that is mentioned in Islam with respect to marriage, that how can it be said to be integral part of a particular religion? It is something that is a secular activity. It is something that is a secular activity, something that is not non-religious. It does not define religion, because if it would have defined religion, now come to the Constituent Assembly debates. The Constituent Assembly debates, when it was about whether it is against the violation of religion or our right to religion, or will it lead to tyranny of majority over the minorities. In these two, there was a very passionate speech that was given by an individual called as K.M. Munshi, and he focused on this idea. He said, first of all, when we talk about it being violation of our right to religion, this is not true. This is not true. Hence, that is not the case, and we have just proved it. That Article 25 of the Constitution, what does it say? And when it comes to whether something is integral to a religion or not. Hence, existence of such mechanisms or such procedures, can it be considered integral to a religion? No, it cannot. Secondly, will it lead to tyranny of majority over the minorities? The answer to this is also no. Why? Because if you look at the certain aspects of it, like if we take certain points, first of all, when it came to this idea, K.M. Munshi gave an example of countries such as Turkey and Egypt. K.M. Munshi was of the opinion that if these practices were integral to a religion, in that case, countries such as Turkey and Egypt, which is a declared Islamic state, they would not have given up such practices. But in such countries, they have given up this idea of the Shariat, and they have also accepted a uniform civil code. They have accepted a uniform code which guides such practices. So if it was integral to a religion, so how come a country which has given up, which is a declared Islamic state, how can they still follow, or how can they follow this idea of a uniform code? That is not the case. Second of all, K.M. Munshi was of the opinion that even when Shariat was being adopted, that in the British period, when when this law, this this separate code was being adopted, even then some minority groups who were following certain mechanisms, they were not happy with the adoption of the Shariat. Why? Because even Muslims who were in India, basically Muslims, if we go through the historical roots, you will find that they have converted. So in that case, during that particular time, there have been a lot of, when Shariat was being adopted, there were lot of communities within the within the Muslims itself who were actually following Hindu laws. They were following Hindu laws. They were following the same mechanisms. They were following the Hindu procedures, and hence they were not happy with the adoption of the Shariat. So now what happened when you implemented this? If Shariat was being implemented, and if Shariat could have been implemented despite the fact that there was a section of the society within even Muslims who did not want the implementation of Shariat, but you did not take into account their rights, then they were also minorities. When you did not take into their rights then, so why is it that when we talk about uniform civil code, or when the Constituent Assembly is discussing the uniform civil code, why is it that you are against this? If you could not have, if the then minority say was not taken into account, then why should the Constituent Assembly do it right now? Third, he said that when people tend to, from different communities, when they tend to move out of our country and move to countries such as, or some European countries, in these European countries, they have to accept uniform civil code. They have to follow the code that has been present, or that is in existence there, and they tend to do what? They tend to accept it then. So if you tend to accept the code when you are residing outside the country, you tend to there are lot of individuals who belonging from different communities. You go there, even Hindus, because we are talking about Constituent Assembly debates. So that at that particular time, uniform civil code was not there, which meant that even in Hindus, the practices that were there were certain problems there also. It was not a code that was this. It did not talk about equality of rights, etc., etc. So when Hindus, or for that matter Muslims, or anyone who migrates from India to such European countries, or when they are living in such European countries, they follow uniform civil code. They are under the code of that particular country, personal laws of that particular country, and you follow the personal laws then. So how is it that when you come to India, or when you are practicing in India, then that is a problem, but when you go to Europe, then that is not a problem? That is also something that was there. Fourthly, K.M. Munshi was of the opinion that if you look at it from administrative grounds as well, from administrative grounds, if you do not adopt for a uniform civil code currently, that is during Constituent Assembly, what is going to happen is that you will have to come up with piecemeal legislations. Piecemeal legislations, example of piecemeal legislations is the Triple Talaq law, wherein we have specifically banned a certain practice, one practice. Similarly, prohibition of sati, another practice which was banned. Similarly, there were a number of other practices. In India, there are Daya Bhaga scheme in West Bengal, etc., etc. It talks about what are the rights that women and men enjoy with respect to inheritance. And because to come up with those, if we do not follow a uniform civil code, Munshi was of the opinion that this would lead to adoption of piecemeal legislations. एक प्रॉब्लम दिखता है, उस प्रॉब्लम को रिजॉल्व करने के लिए हमने एक लॉ बनाया, फिर एक नया प्रॉब्लम आएगा, उसके लिए हम फिर एक नया लॉ बनाएंगे, फिर एक तीसरा प्रॉब्लम आएगा, उसके लिए हम एक तीसरा लॉ बनाएंगे. Piecemeal. Piecemeal means when it is necessary, you enact a law. This is called as piecemeal legislations. When it is necessary, you enact it. And this will further lead to certain problems. Why? Because it would further create that, no, at that particular time, Munshi was of the opinion that if you do not adopt it right now, tomorrow the upcoming governments will face problems. Why? Because they will have to come out with some piecemeal legislations redressing this. Why? Because right now, if we do not adopt it in the constitution, it will not have that legal standing later on. And then the government will have to do what? They will have to come up with piecemeal legislations, which is so correct. So you can see that Munshi actually mentioned this idea, and this is what we are doing today. Why? Because we did not adopt for a uniform civil code, though it is mentioned in the constitution, but because we have not adopted it. So today we will have to, today we will have to criminalize triple talaq. Tomorrow it may so happen that the Supreme Court declares another practice called as nikah halala, which is again a practice that is going on, and the Supreme Court declares it to be unconstitutional. Now when the Supreme Court declares it to be unconstitutional, now again what will happen? Then there will be a law needed for, again criminalizing nikah halala. These are piecemeal legislations. Rather than doing this, if you opt for at one go, just adopt uniforms, civil code, there is no need for coming out with such piecemeal legislations. At one go, we will do away with any such practices. He said this as well. Further, he also in his speech, he also put up a very valid point that when it comes to such practices, why is it that these practices are always discriminatory and derogatory towards a certain section? Why is it that it is always about women? Why isn't these practices discriminatory against men? Because these are not discriminatory against men and it is always women who are to be targeted. That is the reason why we need to do away with such practices. He said there is a need to do away with such practices. Though he did not mention something, but we can add here. What can we mention? Like, though at that particular time, that is in Constituent Assembly debates, fundamental duty was not conceived. In our constitution, part 4A, next part, that is, it deals with fundamental duties. It deals with fundamental duties. And for this chapter, this part was added to our constitution by the, it was added to our constitution by the 42nd Constitutional Amendment Act. Part 4A, fundamental duties. But if you look at the fundamental duties, if you go through the fundamental duties, you can add to what K.M. Munshi had to say. K.M. Munshi did not conceptualize of an idea called as fundamental duties. We have that as of today in our constitution. And one of the fundamental duties is to do away with practices which are derogatory towards women. That is also a fundamental duty, to do away with practices that are derogatory towards women. Now, let's look at what the Supreme Court has to say. When it comes to Supreme Court looking at the position of fundamental rights, directive principles and fundamental duties. So what is the Supreme Court's opinion about the relationship between fundamental rights and fundamental duties? Or if we just look at what the Supreme Court has to say about fundamental duties. The Supreme Court in a case called as Vishaka versus the state of Rajasthan. In this case, the Supreme Court declared that fundamental duties are not enforceable by itself. Fundamental duties are not enforceable by itself. It requires a law. That means to make it enforceable, we require a separate law, a separate legislation, and through a separate legislation, we can make fundamental duties enforceable. However, the Supreme Court went ahead and said that fundamental duties, though it is not enforceable, however, if there is a practice which in any manner takes away or encroaches upon the rights of some other section of the society, in that case this fundamental duty can be considered as a check, or fundamental duty can be considered as a restriction on exercise of those rights. Which means, suppose I am, the fundamental rights that are there. If fundamental rights, in following our fundamental rights, if I enjoy some rights, but while I am exercising these rights, if I suppose encroach upon the rights of others, in that case, this fundamental duty becomes a restriction on fundamental rights. Now, when we say existence of certain practices, such as practices of polygamy, or when we talk about lack of inheritance rights, maintenance rights, or for that matter, adoption rights, or for that matter, divorce rights, when there is restrictions of these rights, can we consider it to be, in exercise of my religious or my fundamental, right towards religion or religious practices, such practices do not it encroach upon the rights of others, where you are practicing your religion, but it is encroaching upon the rights of others. Others means a certain section of the population, that is, in this case I am referring to women, a substantial section of the population. So how can those rights be, how can we consider that this is a reasonable right? It can never be considered as reasonable. When a right is encroaching upon the rights of others, how can it be considered a reasonable right? Practices such as polygamy, it denies dignity to women. Practices such as nikah halala, it is absolutely derogatory towards women. It is absolutely derogatory towards women. The way it is being conceived, it is absolutely derogatory towards women. When we talk about lack of adoption rights, once under Islam, followers of Islam, or if there is a marriage that has happened and an individual, women are suppose divorced, in this case they do not have maintenance rights. They do not have maintenance rights first. That means the husband is not supposed to provide any kind of maintenance to the women, except for the fact that during the marriage itself there is something that has been decided called as meher ki rakam, and that is what is to be paid. Except for that, there is nothing that is to be paid. They do not enjoy inheritance rights. They do not enjoy maintenance rights. They do not enjoy the adoption rights. In fact, under this, automatically the supervision of children and what you can say, the laws, so they are so framed that automatically the husband gets the right to maintain children, not women. They are denied of these rights. So how can we say that these rights are not derogatory against women? How can we say this, that it is not derogatory against women? And even if you go by the judgment of the Supreme Court, we have a duty, and because though these fundamental duties are not enforceable, but in this case when they are denying a particular section of the society with certain rights, it is mandatory for the state to do what? It becomes somehow mandatory for the state to take actions to ensure that such rights are extended to the certain section of the population. And that is the very idea. If you look at maintenance rights, I was talking about maintenance rights, and you can see an example there, the Shah Bano case. What happened in the Shah Bano case? In the Shah Bano case, Muhammad Akbar Khan, who was the husband and Shah Bano, they were married for 40 years. They were married for 40 years. When Akbar Khan gave triple talaq to Shah Bano, who was then 73 years old. When she was divorced, she was 73 years old. And because the Sharia says that, it talks about a certain contract there, and because, according to the Sharia law, the contract was upheld. The contract was upheld. So Akbar Khan had no what you can say duty to pay maintenance to Shah Bano. There was no when in the lower court, this was appealed, the lower court extended maintenance rights to Shah Bano, and Akbar Khan, who was himself a lawyer, challenged this decision of the lower court in the Supreme Court, saying that I am being denied of my fundamental right to religion because I am practicing my religion, and this decision that has been there, it is against that. The Supreme Court, when the Supreme Court was faced with this, the Supreme Court took a very different opinion, extending section 125 of the Criminal Procedure Code in this particular case and giving maintenance rights to Shah Bano, because criminal procedure is extended and similar for everyone. It is civil procedure which is different, but in criminal laws are similar for everyone. And hence the Supreme Court did what? In this particular Shah Bano case, the Supreme Court did not take that civil view of the case. The Supreme Court extended section 125 of the CRPC, that is Criminal Procedure Code, to this particular case and extended maintenance rights to Shah Bano. And the kind of political uproar that happened because of it. The Supreme Court's decision led to a political uproar. Initially, the Congress party supported. See, you have to see maintenance rights to a 73-year-old individual. She's not 30, 40. In according to Indian laws, she is a senior citizen. According to Indian law, she is a senior citizen. So now she is not eligible to work. She is not eligible to work. The state will not provide her employment. Neither would any other private companies providing them with employment. So she has no other way to maintain herself. Now, how can we say this is not derogatory towards a certain section, towards women? How can we say that? How can we consider it to be only a religious act? How cannot we consider it, or why should not we consider it to be a secular act? And on this basis, extending section 125 of the Criminal Procedure Code, which talks about maintenance of widows, maintenance of parents, etc., etc. And this was extended to this particular case, and the Supreme Court declared that Muhammad Akbar Khan is eligible to pay maintenance to Shah Bano. And this led to a political uproar. The Congress party initially led by the Rajiv Gandhi government initially supported the decisions of the Shah Bano judgment. It was initially supported by Rajiv Gandhi. However, there were elections that happened in some states, two of the states, and the Congress party lost elections. And it was said that one of the reasons why the Congress party lost elections was that Rajiv Gandhi openly supported the Shah Bano decision. And that is the reason. And that is the reason why Rajiv Gandhi enacted a law in 1986 after the Shah Bano case. The law specifically undid the decisions of the Shah Bano case. It did what? The law specifically said protection of women from protection of Muslim women from Divorce Act 1986, but it did not extend protection, rather it denied them the protection, because the law explicitly says that in these cases, that is in cases when it comes to divorce, section 125 of the CRPC, which was extended by the Supreme Court in the Shah Bano decision, that particular section was exempted, that divorce of Muslim women, and in these cases section 125 of the CRPC cannot be extended. This was the very law. No, the objective of the law was this. So though it talked about protection, but it denied them the protection. And because of the kind of steps and the kind of problems that the Rajiv Gandhi government faced, no other political party, they considered it to be too sensitive issue, and they did not interfere with enactment or adoption of the Uniform Civil Code. I have only one question. I have discussed this idea. I have only one question to you. What is the problem with our strategy towards this? If you look at the developments, I have talked about the developments. I have talked about how Pandit Jawaharlal Nehru, because of his liberal mindset, just post, as soon as elections were held and the first government of the independent India was formed, he actually authorized the adoption of a uniform civil code, which led to an enactment of Hindu code rather than a uniform civil code. It led to an enactment of Hindu code. What is Hindu code? Now, if you can search the internet on it, and you will find there it is a set of 4 laws. It is a set of 4 laws which are called as the Hindu code. That's not that important. It led to the enactment of Hindu code, and since then, that is 1950s till 1980s, though there were some developments over a period of time, it used to be, but the major development came in 1985 on the Shah Bano decision, and then the enactment of 1986 law, and then in 2014 the BJP declares it to be one of its, a part of its political manifesto. If you look at these ideas, if you look at the developments, if you look at the debates that we have, that the Constituent Assembly had, what K.M. Munshi had to say, all these things, I have only one question. The question is, what is the fault with the kind of strategy that we have adopted for this? What do you think? Okay, let's start with this, a simple question. Should we adopt Uniform Civil Code? Yes. So why have we not? After 70 years, it's not that हम ही सारे बहुत समझदार हैं और कोई और समझदार नहीं है, ऐसा तो नहीं हो सकता. Saying that there is no such understanding that existence of the partial implementation of the Sharia law that is there, it specifically is derogatory towards women. Now, no one can say that this is not the case. ऐसा तो नहीं है that only we understand that what is the problem. There are other sections of the society also. They also know what is the problem. There are so many individuals who understand law. There are so many individuals who if they do not just understand law, they also know what should be the standards that we should have in a society. So why is it that we have not enacted for, or we have not till now, we still struggle with this, even conceptualization of this idea, not just with this idea of a uniform civil code, we struggle with the conceptualization of a uniform civil code and the strategy that is there, that is involved. What is the problem with it? Yes, due to vote bank politics. Because do you think that is wrong with our strategy? See, political parties are going to do that. We cannot assume that a political party, we cannot assume the political party to do anything which is absolutely moral and all these things. We cannot assume that a political party is going to do that. Any kind of democratic system that you see, in India's democratic system, you will find there is something called as, obviously what you said, as vote bank politics, or what we can consider as an appeasement policy that goes on, that has been going on. That is not just true for India. Any country in the world, any democratic country in the world, you would find that is something that is going on. That is something that is done. My question is, what is wrong? What is the problem that you see inherently here? What is the problem? Patriarchal nature of our society. लेकिन इसी पेट्रियार्कल नेचर, डिस्पाइट दिस पेट्रियार्कल नेचर ऑफ आवर सोसाइटी, वी हैव बीन एबल टू गेट रिड ऑफ नंबर ऑफ प्रैक्टिसेस. सती हमने खत्म कर लिया, ठीक है. वी हैव इनफैक्ट इन पोस्ट 1956 वी हैव taken up a lot of amendments to certain other religion. Since 1980s we have provided inheritance rights also to women. Hindu mein women, no, in Hinduism women have inheritance rights. What is the problem? Yes, we are considering it as a challenge against women. Towards women, we need to look into interest of women rather than considering it to be a minority issue. So rather than considering it to be a religious issue, we need to consider it to be a social issue. Okay, anything else? So don't you think there is this understanding is there that rather than considering it to be a religious issue, we need to consider it to be a social issue? The problem is there is absolutely a lack of debate in the social sphere about this particular idea. आपने कभी भी किसी देखो, even if you look at the debates that generally tend to happen on this issue, or it will happen on this issue, it is always about a particular religion. We tend to consider it to be a religious issue, but the thing is that it is not. What she says is absolutely correct. It is not a religious issue. How can it be a religious issue? If it was a religious issue, then there are so many countries in the world which have adopted for a uniform civil code, despite the fact that they are Islamic states, or for that matter they are secular states. In fact, in India, leave aside other countries, in India there is a state in India, Goa, and in Goa we have a uniform civil code. Goa has a uniform civil code. Every individual, every religion that is there, they are dealt with uniformly. There is no presence of dual or multiple personal laws. There is existence of only one personal law. Why? Because in India there is a complete lack of social debate on the issue. There is no such debate. Even in news channel, India में क्या news channel में तो debates होते नहीं है, ठीक है, उसमें चिल्लाना ही होता है, but फिर भी, even if you look at such debates, you will always find that this is considered to be a religious issue. It is not. It is not a religious issue. How come a country like India, in a country like India which has more than 55% of the population which is under 35 years of age, under 35 years of age, if you look at the population of India, the demography of India, in demography of India there are 55%, more than 55% of the total population which is less than 35 years of age. India has a young population. How do you think that this 55% will accept or does accept such norms such as what has been mentioned under the Sharia law, or for that matter any other cultural or such practices that we have which is derogatory against suppose women? Does this 55% have an acceptance about such practices? It will never happen. Existence of a dual code or multiple code in India is against democratic norms. जब 55% of the population is not accepting it, will not accept it, how can you still consider that these things should be prevalent or these things should still continue? Even if it is something that is integral to a religion, the constitution does not say that the religious rights that we have, they are absolute rights. They are not absolute rights. Existence of provisions, like very recently we have acted on triple talaq, and if you look at the debates and discussions, you will find that there are no, even population and the MPs, they are talking about this idea that in Islam, because marriage is a contract, now marriage is a contract and hence it should be upheld, and these practices that are there, it should be taken in this connotation, in this way. But the question is that even if that is the case, can we say such a contract, can we still continue with such a mechanism, even if it is a contract, despite the fact that it is derogatory against women? Shall we continue with it? Should we continue with it? Or is there a need to redefine such provisions? There is a need to redefine it, and hence the need for or existence of law. And similarly, if you go by constitutional ideas itself, constitutional ideas, it prohibits, Article 14 of the Constitution prohibits the existence of dual personal law. It says equality before law. Article 15 of the Constitution says that the state shall not discriminate among citizens on the basis of sex, and that is one of the religion or sex, and both of these provisions are present here. Article 15 says that. And any existence of any law, which means what? The state is implementing such a law. The state is implementing such a law. So not only is it contradictory against, not only is it contradictory for the rights that women enjoy, it is also contradictory to the very Constitution of India. It is still contradictory, and there have been number of instances in which the Supreme Court has also directed that there is a need to adopt a uniform civil code, and there is a need to implement a uniform civil code. When it can be done in Goa, why cannot it be done in other states in India? Why cannot it be done? It is not majority versus minority issue. It is an issue which we need to look at it from a social angle. What about rights of women versus men? This is what we need to look at it. So what is the problem? The problem is we tend to see this as a religious issue, but it mainly is a social issue and not a religious issue. Clear? This is all about uniform civil code. Clear? This is all about uniform civil code. So what we need to see is, first of all, you need to know about the decisions of the Shah Bano case. Not specifically decisions of it, rather you need to just know this, that section 125 of the CRPC, which deals with maintenance rights of parents, widows, as well as those individuals, those women whom for whom their husbands are in jail. These things are there mentioned under CRPC. It deals with maintenance, and that was extended to this particular case. Clear? So there are certain ideas that are there, you can write them. Uniform civil code. What? Maternity and paternity. What? Testing, is it allowed or not? ये पूछ रहे हो. Is it a part of it or not? It is a part of it. देखना पड़ेगा. I don't exactly know that whether it is a part of it or not. I'll have to see that. Okay. Uniform Civil Code. Article 44 of the Constitution. Article 44 of the Constitution reads, the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The Constituent Assembly debates provided for two objections in adopting a uniform civil code. First, it would infringe the fundamental right to freedom of religion. It would infringe upon the fundamental right of religion mentioned under Article 25. And second, it would be a tyranny to the minorities. Tyranny to the minorities. The first objection is misconceived as Article 25 Clause 2 provides for exceptions to Article 25 which says that the state can enact laws to save secular activities associated with religious practices from the guarantee of religious freedom. The second objection, that is tyranny to minorities, also does not stand, as according to K.M. Munshi, nowhere in advanced Muslim countries, personal law of each minority has been recognized as so sacrosanct as to prevent enactment of a civil law. Also in Europe there is an existence of a uniform civil law, and everyone who is a part of it, including the minorities, have to submit to such law. Munshi was also of the opinion that lack of a uniform code would result into piecemeal legislations, which would be difficult from administrative point of view. Also, such laws are derogatory against women, as it does not provide them equality in inheritance, maintenance, etc. Therefore, substantiating the need for the adoption of a universal code. Next paragraph. Post independence, no such steps was taken to provide for a uniform civil code. Only law of marriage succession, guardianship, maintenance among Hindus were given some uniformity in the mid 1950s. The Supreme Court in the Shah Bano case upheld the right of maintenance of a Muslim divorcee under section 125 of the Criminal Procedure Code, which further deteriorated into enactment of a separate law for Muslim divorcees. The current government, you can add one more point here. The current government has referred the issue of a uniform code to the Law Commission to recommend on the desirability of such a code. You can also add the 42nd constitutional amendment. Which added fundamental duties to our constitution, states one of the duties to be to promote harmony and the spirit of common brotherhood, amongst all people of India, transcending religious, linguistic, regional or sectional diversities. Regional and sectional diversities, and to renounce practices derogatory to the dignity of women. Clear? So this is the whole idea. You can there are a lot of things that you can add here. What fundamental rights say and how the current practices may be contradictory to what fundamental rights have to prescribe. Certain things you can add. Clear? But basically, what are the developments? I have added it as a part of a uniform civil code. Again, as I said, there was a question that was already asked on uniform civil code in 2015. The question was already asked, but you can still get a question on it. Okay. So this is what is Article 44 of the Constitution. Under brackets you can write which fundamental duty is this? Which fundamental duty? This is the fundamental duty, that no, derogatory against women, renounce practices that are derogatory against women. When you have written that, it is a fundamental duty as a part of Article 51A Clause E. Clause E. That is the fundamental duty wherein it mentions we need to renounce practices derogatory against women. Clear? With this, we complete our discussion on Article 44 of the Constitution. Next, this is the most important of it. We have already discussed one of the directive principles under Article 50. What was it? Yes, judiciary and executive shall be separated from each other. When we were talking about separation of powers, we had already talked about Article 50. So there are two of the fundamental duties which we have already dealt with. Clear? Next comes Article 38 of the Constitution. Some fundamental duties additionally we need to look at. So suppose you get a question. Suppose you get a question in your examination which deals with the nature of fundamental rights, the nature of directive principles. Now the question is, directive principles, the directive principles are directives to the state to establish a social and economic democracy. Substantiate. Which means what? Now you have to write specific provisions of the directive principles which ensures existence of a social democracy, or for that matter existence of a economic democracy. So under Article 44, now this is an example of what? Social or economic democracy? It is an example of social democracy, because we empower every section of the society, equal rights. It is about equal rights. So it is about social democracy. So Uniform Civil Code is also something that guarantees existence of it. If we implement it, it also guarantees what? It guarantees a social democracy. Clear? So let us look at certain examples through which such kind of questions that are there, which will explicitly deal with directive principles and how you can substantiate those. First is Article 38. Article 38. What does Article 38 say? First, write this. The state shall strive to promote. The state shall strive to promote welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. Next paragraph. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst but also amongst groups of people residing in different areas or engaged in different vocations. Article 38. This is what Article 38 says. What does what is the objective of Article 38? Yes? is the objective only economic in nature? The objective, if you look at the first paragraph that you have written, which is Article 38 Clause 1. Article 38 Clause 1 fulfills that aspiration that we had discussed in the preamble. What was that aspiration? Justice. And what kind of justice does the preamble secure or wants to secure to all citizens? Social, economic and political. So the concept of justice that we have seen as a part of our discussion in preamble has been mentioned as a part of Article 38. It has been given as a part of directive under Article 38 of the Constitution to the state, that the state has the responsibility to ensure that effectively as possible, the state shall ensure justice. Justice not just economic in nature, social justice, economic justice as well as political justice. And what is the difference between the first paragraph and the second paragraph? Yes. What is the difference between Article 38 Clause 1 and Article 38 Clause 2, which you have written as a part of second paragraph? Yes. It is talking about economic inequalities. Anything else? Equality of status and opportunity. Okay. The first aspect is, remember, we have again, go back to preamble, we have discussed equality. And what kind of equality has been mentioned in the preamble? Equality of status and opportunities. So if you look at Article 38 of the Constitution, Article 38 Clause 2, which you have written as a part of second paragraph, that has an objective of guaranteeing that part of the preamble, which says equality of status and opportunities. But is it only the thing that is different from Clause 1 and Clause 2? Clause 1 talks about justice and Clause 2 talks about inequality. Anything else? Yes?
Protection of linguistic culture and linguistic also including.
No. If you look at the first paragraph, Clause 1, it is individual, and Clause 2 provides us with group rights. It talks about group, not just about individuals, it also talks about groups. So inequality in group and vocation. Now inequalities of group and the kind of different kinds of vocations that we are there. Now that we follow. Clause 2 was added to the Constitution. It was not an original part of it. It was added to the Constitution by the 44th Constitutional Amendment. It was added by the 44th Constitutional Amendment. Just a fact, not necessarily you have to remember this. It will be very difficult if you try and remember all these. But still. So if you look at Article 38 of the Constitution, the objective of Article 38 of the Constitution is to give us, or it is to provide for equality and justice, and equality not for just individuals but equality of groups, equality of individuals along with that equality of groups. So the preamble, again go back to this question, social and economic democracy. So Article 38 of the Constitution, it is one of the primary articles that you mention to substantiate your answer that on the question that I have just mentioned. Clear? This is what Article 38 of the Constitution is. Underline equality, underline justice, underline group. How it is individual? Article, how is Clause 1 how is Clause 1 dealing with individuals and not groups? Because it has been mentioned in Clause 2. Clause 2 says what? Says opportunity not only amongst individuals but also amongst groups. So because Clause 2 explicitly mentions the idea of group, we can say that Clause 1 only talks about individuals and not groups. That is the very reason. Next, Article 39. So why is Article 39 important? Yes? Yes. When we talk about Article 39 Clause B and Article 39 Clause C, they they even supersede Articles 14 and Article 19 of the Constitution. So these two are those directives to implement which, if the state has come out with a law, if the legislature enacts a law, and even if it is contradictory to the provisions or the fundamental rights mentioned under Article 14 and 19, it would still be valid. So Article 39 is very important. But we are only going to deal with Article 39 clause B and C, because others are not that important. Clear? So Article 39, what does it say? It says that the state shall follow, write this, the state shall in particular direct its policies towards securing within subpoint Article 39 clause B, subpoint just give a hyphen and write 39 clause B. That the ownership and control of material resources. What does clause B say? It says that the ownership and control of material resources are so distributed as best to serve the common good. 39 clause C, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. Common detriment. So what is Article 39B and how is it different from Article 39C? For private resources, you are not completely wrong, but there is something more. She is absolutely correct when she says, if you look at the directive that is mentioned under 39 clause B, it is a directive given to the state as to how public resources are to be used. What is the key term there? For common good. It is to be used for common good, not for good for a certain section of the population, but something that results into a common good. Even if the public resources are so used that it benefits a certain section of the population, the result should be common good. Secondly, the Article 39 clause C that is there, it is a directive to ensure that the resources should not damage common good, or absolutely correct when she says the idea that it should not lead to concentration of resources and factors of production. So if you look at B and C, the difference is that B is a directive to take up certain steps to help those individuals, and C are the directives to ensure, to restrain. First is the directive, it is like a positive directive given to the state, how to use your resources. C is a directive that is how to constrain. Now, what are the steps that the state shall take to constrain what? Constrains the concentration of wealth and factors of production. Now, nationalization of banks. Yesterday we were discussing Privy Purses Abolition Act. What was it? It was against concentration of wealth and factors of production. Though we cannot say that it only fulfills directive under 39C and does not fulfill directive under 39B. 39B says state shall take for common good. So the state has nationalized bank for common good. Abolished privy purses for what? For common good. So to implement 39B and Article 39C, the state had taken up those particular steps. Clear? This is what is 39B and C. Very important is the nature, to understand the nature of 39B and C. You can write in the next paragraph. This is one of the most important directives because it supersedes even fundamental rights. Next paragraph, right? This article specifically requires the state, this article specifically requires the state to ensure for its people adequate means of livelihood, fair distribution of wealth, comma, equal pay for equal work, and protection of children and labor. This is 39D, which we have not discussed, but you should know the nature. Further, right? Article 39B and C together, contain the objectives to build a welfare society, and an egalitarian, from the word equal, EGALITARIAN, egalitarian social order. See, by implementing Article 39B and C, not only does the state specifically deal with economic resources, but implementation of Article 39B and Article 39C, which results into an egalitarian social order, basically leads to ensuring the dignity of people. So Article 39B and C is also directed towards achieving or ensuring, state taking up steps to ensure that every individual enjoys dignity. So when we talk about Article 39 clause B and C, you can also look into this Article 39B and C as guaranteeing us right to life under Article 21. Right to life under Article 21. Why? Because Article 21 guarantees us a dignified life, not just a life, but a dignified life. So a dignified life would automatically mean living in an environment or in a society wherein we get equal treatment, which would mean in terms of use of economic resources, or for that matter otherwise as well. So when we say egalitarian social order, this idea can also be related to dignified life mentioned under Article 21 of the Constitution. So if you are ever writing on it, don't fail from this, despite the fact that Supreme Court has nothing to say in this regard. Specifically, it has not related to Article 21. But you can see it's very prominently present there that that a social order, an egalitarian social order, is what a dignified life would look like. Now, when I say I have to have a dignified life. So can I have a dignified life without having equal say in a social order or living in an egalitarian social order? No. So Article 39B and C is very much related to Article 21 of the Constitution. The difference is Article 21 of the Constitution is a part of fundamental rights and Article 39B and C is a part of Directive Principles. Clear? Next. Yes. See, Article 39B is directive for how the state should use common resources. Article 39C is the state, again it is a directive for the state wherein the state is going to take certain actions to ensure, not No, it is not going to just ensure how it is going to use its resources, but also it has to ensure that there is no concentration of resources among few. So if you look at the nature, B is more positive, C is a bit negative, constraining. B is about doing certain things for giving some, C is about constraining. But the objective is same, a social and egalitarian social order. Clear? Next. Article 41. Article 41. It states, the state shall within the limit of its economic capacity, and development, make effective provision for securing the right to work, comma, to education and to public assistance in case of unemployment, comma, old age, sickness and disablement, and in any other undeserved want. Underline here, limits of its economic capacity. So what does this mean? It simply means that, again, Article 41 of the Constitution reinforces the idea of welfare state. It reinforces the idea of welfare state. If you remember, yesterday we did differentiate between laissez-faire and welfare state. What did we say? Laissez-faire state is a state wherein the state has limited functions. The state has nothing to do with taking up welfare activities. But if you look at Article 41 of the Constitution, it truly spells out the character of Indian state. It is Article 41 which spells out the character of Indian state, wherein the state is to ensure within its economic capabilities. Obviously, it will vary within its economic capabilities, that the state provides right to work, right to education, as well as public assistance in certain cases. What are the cases? Any kind of undeserved want, which means no one deserves disability. No, we cannot say that this individual deserves this. No one deserves disability, no one deserves sickness, no one deserves the handicaps or the limitations that comes because of old age. So these are what? These are undeserved wants, and the state within its economic capabilities would provide for assistance, public assistance, to those individuals who are there in these categories. Similarly, the state also will provide for, not only for undeserved wants, but also for others. What? Right to work, if it can provide it within its economic capabilities, obviously. Also, right to education. Clear? So whenever we talk about Article 41, the best idea to understand Article 41 is when we say it spells out the welfare nature of the state, or it spells out the welfare nature of Indian government. So you can write this in brackets. Article 41 spells out the true nature, that is welfare of the Indian state, However, Article 41 of the Constitution has no bearing on Article 16 of the Constitution. What is Article 16? Equality of opportunity in case of public employment. Clear? So on the grounds of Article 41, Article 16 cannot be tampered with. This is what it means. No, this is what it means, that on the grounds of Article 41, 16 cannot be tampered with. It has no bearing on Article 16 of the Constitution, which provides us equality in opportunity when it comes to public employment. Clear? Next, Article 46. Article 46. The state shall promote with special care the educational and economic interests of the weaker section of the people, and in particular scheduled caste and scheduled tribe, and shall protect them from social injustice and all forms of exploitation. So underline here educational and economic interests, underline weaker section of the society, and underline also social justice and all forms of exploitation. What is the difference between Article 15 of the Constitution, Article 23 of the Constitution, and the Article 46 of the Constitution? If you look at Article 15 of the Constitution, which also talks about discrimination, Article 15 also if you look at exceptions of Article 15, exceptions, within exceptions it has been mentioned the state can take up provisions for in favor of backward section of the society, including scheduled caste and scheduled tribes. This has also been mentioned. Exactly, if you look at it, Article 15 clause 4, it talks about this. Article 15 clause 1 says no discrimination. Article 15 clause 2 says no discrimination with access to public places. Article 15 clause 3 says what? Women and children. In favor of women and children, the state can take certain special provisions. And Article 15 clause 4, which was introduced by what? The first constitutional amendment. It says what? It says the state can also take up certain acts or make certain provisions for promoting the interest of the weaker section of the society, including that of scheduled caste and scheduled tribes. तो ये तो लिखा हुआ है ना, 15 clause 4 में लिखा हुआ है. Why was it necessary to repeat it in when you say Article 46 of the Constitution? Yes, but that is what is mentioned. That is what has been mentioned under Article 15 clause 4. The state can make provisions. So don't you think provision would include policies? Yes, just a minute. हाँ.
This is in particular SCs and STs.
बिल्कुल गलत है ये. अब बोलो.
This article is more comprehensive in nature.
It is more comprehensive in nature. Yes. Why? Social injustice. हाँ. And there. Absolutely correct. देखो difference है. The difference is, if you look at Article 15 of the Constitution, Article 15 of the Constitution is basically a directive for the state to make special provisions to promote the interest of scheduled caste, scheduled tribe, as well as the other backward section. But if you look at Article 46 of the Constitution, it says what? All forms of exploitation. So not only discrimination, not only ensuring that the state does not show any kind of discrimination, but Article 46 also directs the states to ensure that no one shows any kind of discrimination against scheduled caste and scheduled tribes, or for that matter the weaker section of the society. If you compare Article 15 clause 4 with that of Article 46, you find that Article 46 is more comprehensive in nature. It is more comprehensive because it says that the state has the responsibility not only just to ensure that there is no discrimination, but also to ensure that this discrimination is not taken up by any section of the population, not just the state not taking up discrimination. And the term that is used, now coming to a very important idea, the term that is used there is backward section of the society. The term that is used here is weaker section of the society. Now, what is the difference between these two terms? Are they similar? No. ये तो guess कर लिया आपने. What is the difference? Yes? Weaker section means economically weaker section. And backward section means? Socially backward. बिल्कुल गलत है ये. Weaker section of the society includes economically backward section. Backward section of the society only means what kind of backwardness? If you remember, Article 15 Clause 4 recognizes what? Educational and cultural backwardness. Now, educational and cultural backwardness has been recognized by it. Okay? That is what has been recognized in the form of backwardness. Here, when we say weaker section of the society can be defined as not only that kind of backwardness, but it also means economically backward. So, when we talk about other forms of disabilities or handicaps like poverty, natural and other physical handicaps, which means what? Which means suppose I am living in an area, the terrain of which is very difficult. Don't you think it is a natural handicap for me? I am not similarly connected to the rest of the world as you are. Natural handicapped ho gaya wo. So, when we talk about the term weaker section of the society, this term weaker section of the society is much more elaborate than the term backward section of the society. Clear? You can write here. In next paragraph, write. Article 46 of the Constitution. Article 46 of the Constitution is much more comprehensive, than the rights provided under Article 15, as Article 46 directs the state to protect the weaker section of the society against social injustice and all forms of exploitation. Unlike Article 15, which guarantees only protection against discrimination, and Article 23, which guarantees protection against forced labor and immoral activities. Also, the term weaker section of the society is a wider expression as it connotes or represents all section of the society who are rendered weak due to various causes, including poverty and other natural and physical handicaps, The Supreme Court has also read the right to development in this article, under this article with Articles 21, 38 and 39. Clear? So this has been read along with Article 21, 38 and 39. And basically this decision that was there, wherein the court actually defined this term, what is the meaning of weaker section of the society. It was done in the same case that we had discussed earlier, called as the Indira Savni versus the Union of India case. 1992 case, we have read that, we have read it under article, which article we had actually? Article 15 itself, Article 15 clause 5, which talked about providing reservation to the other backward classes. So we have dealt with that case. In the same case, the court also defined what is the meaning of the term weaker section of the society. Clear? This is Article 46 of the Constitution. Next, Article 47. The state shall regard the raising of levels of nutrition, and the standard of living of its people and the improvement of public health among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except for medicinal purposes intoxicating drinks and of drugs which are injurious to health. So do we have the legal right to sell liquor? No. Though Article 19 of the Constitution provides us the right to occupation, but under the theory of harmonization, the Supreme Court says directive principles can also act as a check on fundamental rights. So Article 47 of the Constitution says what? Article 47 of the Constitution says that the state can prohibit selling of intoxicating drinks and drugs which are injurious to health. So in this case, even though we have the fundamental right to choose our occupation, so I can take up my business, but I cannot sell intoxicating drinks or for that matter drugs. ठीक है कि कोकेन बेच रहे हैं और बोले फंडामेंटल राइट है, that cannot happen. Why? Because it is prohibited under Article 47. The state can enact certain laws, and the Supreme Court has also interpreted it in such a manner. Clear? So this is again, see, health, public issue. No, it is a public issue. Again, the idea of a welfare state. You can see it is an idea of a welfare state. Clear? So this is what Article 47 of the Constitution is. So no one has the legal right to sell liquor. When the state comes out with certain policies, very recently the government of Madhya Pradesh, has come up with, is in the process of enacting a law which legalizes the cultivation of poppy, which is a chief ingredient when it comes to all these drugs that are there. But that is for medicinal purpose. So you will find the state can come up with such a law also, but it is for medicinal purpose. The state will define that in what part of it can be cultivated and what is the limit to such a cultivation. Aisa nahi hai unlimited, that cannot happen because of the restrictions that have been imposed. And if the state comes out with no such restrictions and it is challenged in the court will declare the law to be unconstitutional. It will declare the law to be unconstitutional because it is contradicting Article 47. Despite the fact that Article 47 is not justiciable, but the court might, take up a very different view on it. Like Article 21 or relating it to something like that and then declaring it to be unconstitutional. Clear? So such limitations are imposed, but provided it is for medicinal purposes. So in painkillers, in such painkillers that are there, again such such ingredients are used. The same ingredients that are used in such any kind of drug that causes hallucination. So same drugs are basically used, but it is still cultivated, but there are certain limitations imposed on it. Clear? This is 47. Now can you answer the same question that we were discussing? Social and economic democracy. How does directive principle guarantee, or how does implementation of directive principles guarantee the existence of social and economic democracy? You can see it talks about Article 46 talks about any form of social exploitation. Article 39 of the Constitution talking about ensuring an egalitarian social order. Now all these provisions that are there, in fact, public health, right to work, all these things, ensuring that there is no consumption of intoxicating drinks, etc., etc. All of this ensures what kind of state. It presents the nature of state and what kind of state is India. The government here performs welfare functions. The government performs welfare functions. It is a welfare state. Clear? So if ever you get a question on welfare state, the answer is directive principles. Learn at least these, whatever we have discussed. There are some others also, like organization of agriculture and animal husbandry, improvement of environment, but I'm not dealing with these. These are not that important. Clear? With this, we complete our constitutional discussion on directive principles. The last part of our discussion here today would be importance of directive principles. Give a subheading, right? Importance of directive principles. Importance of directive principles. Before we actually get into fundamental duties, the last part of our discussion here is importance of directive principles. So see, actually I have already answered this question. What I want is how would you present this idea? How would you present this idea? What is the importance of directive principles? If today I say, I come out again, let's discuss this in the form of a question. If you get a question, this question in your mains examination, fundamental rights are justiciable rights, directive principles are non-justiciable. However, this does not dilute the importance of directive principles in governance. Substantiate. What would you write? Again, repeating my question. Fundamental rights are justiciable rights, directive principles are non-justiciable. They are non-justiciable. However, this does not mean or does not dilute the importance of directive principles in governance. It does not dilute the importance of directive principles in governance. What will you write? Or suppose it is a double negative question. Fundamental rights are more important than directive principles. Critically analyze. You can start the question as she very appropriately puts it in this manner, that you can start with Article 37 of the Constitution, which though it says it is not justiciable and enforceable, but it further says it is fundamental to the governance of the country. Article 37 itself declares, though it says that yes, it is not enforceable, but it further says that though they are not enforceable, but they are fundamental to the governance of the country. And she also says that we can also use the decision of the court, wherein the court says that though they are not contradictory to each other, they supplement each other, because the objective is to establish social, economic and political democracy. Absolutely correct. Anything else? Some of the provisions you can talk about. You can definitely talk about some of the provisions of the directives, directive principles, wherein you can mention obviously Article 39, you can mention Article 38, you can mention Article 46 of the Constitution. At least these three you can mention, and you can, with mentioning this idea, you can mention, you have to write it in such a way that it establishes the fact that yes, despite the fact that these are non-justiciable, but it cannot be ignored. Further, what you can write? Suppose, now you have written this idea, one aspect of the question you have written, why it is important. Now the second aspect of the question is also when you can further substantiate this idea by just writing what is the consequence of not implementing directive principles. You can also take this very opinion, this very view of the question, that if you do not implement directive principles, what will happen? Just look at a political party, any political party that is there. And if the political party comes to power and the political party does not take into account directive principles while coming out with laws, it does not take into account directive principles while coming out with laws, while coming out with policies, what will be the consequence of that? Yes? Harmony of what? Yes? Welfare state. What we will miss, or what the political party will miss, is the idea of welfare state. And after 5 years, what is going to happen? The political party loses election. So though it is not enforceable in the court of law, directive principles are not enforceable in the court of law, but they are enforceable in the court of people. And hence any political party which comes to power, cannot ignore them. What is the best political manifesto that a political party can have? Directive principles. These are the best political manifesto for any political party. If they elaborate upon directive principles and promise to the people of India or to the people of that particular state that we are going to implement directive principles. And that is the reason why B.R. Ambedkar said this is a lighthouse. Now directive principles, the nature of directive principles is that it is in nature of a lighthouse. What is the job or what is the work that a lighthouse performs? When at night, when that lighthouse is lit, the ships which are coming, they get to understand what is their goal. That means where they have to achieve, where they have to go. There is no confusion with respect to that. They understand, okay, that is the harbor, we need to be there. Similarly, for a political party, directive principles is like a lighthouse which will establish, or which from time to time it will act as a lighthouse for the political party to get to know, okay, where we have to reach. That means what are the objectives that we should have. These are the objectives that we should have to achieve the welfare goals which are given or which are explicitly mentioned in the directive principles. So that is the case. B.R. Ambedkar mentions it as the lighthouse. Clear? So you can give the views of B.R. Ambedkar as well. Clear? So when you get this question, directive principles, you can elaborate in this manner. Suppose you get a question on the second question that I said it is a double negative question. I said fundamental rights are more important than directive principles. Critically, analyze. Which means you will have to write both the provisions. You cannot just mention, okay, why is fundamental rights important? You also have to mention why are directive principles important and why sometimes directive principles become more important than fundamental rights. Because the idea, you can mention about the idea of democracy, not only political, social and economic democracy. You can mention that even the Supreme Court has realized the importance of directive principles in the theory of harmonization. You can mention that. You can also mention how under Article 46 of the Constitution we have seen that the Supreme Court says it is to be read along with Article 21, Article 38 and Article 39 of the Constitution. Article 21 guarantees us what? Right to life. And Article 38 and 39 of the Constitution, which talks about justice and equality and an egalitarian society, it does what? It re-establishes or substantiates or reinforces the idea under Article 21 of the Constitution. How can we get Article 21 or achieve Article 21 without implementation of 38, 39 and 46? How can it happen? It is not possible. So these two are not now you can understand why the Supreme Court has opted for theory of harmonization. Supreme Court says it is supplementary, not contradictory. It is supplementary. Why Article 46 of the Constitution talks about social injustice, but though Article 15 clause 4, it says that there can be some provisions taken up by the state, but still it is mentioned under Article 46. Why? Because when we talk about Article 46, remember, directive principles are dynamic in nature. So the challenges that are faced by these communities, when we talk about the weaker section of the society, including scheduled caste and scheduled tribes, the challenges that are faced by the community, they are not static in nature. So how can you include it as fundamental rights? Fundamental rights will have to be objective. If it is not objective, it will not make any sense. Directive principles, the language of directive principles are, it is in such a manner that it is evolving in nature. So tomorrow, on the nature of problems that are faced by a community, accordingly the state can take up certain steps. Clear? So this is the reason why Article 15 clause 4 also exists and Article 46 also exists. The evolving and the dynamic nature of directive principles. Understood this idea? Have you understood the importance of it? So now will you be able to write any question that comes from this very idea? Clear? See, generally this is not the time that is allocated to directive principles. We do not give it so much time, but I have given it 2 classes completely. That means 5 hours. और 5 घंटे में सिर्फ मैंने बोला है. So you can understand the reason, because I am telling you, you will get a question on directive principle. In your mains examination, it is definite you get a question on directive principles. It may not be explicit, but you need to understand and recognize where you will be able to write it. And that is the reason why I have elaborated it so much. Clear? Write this down. Importance of directive principles. Those things that I have already discussed, I am not elaborating it again. I am just adding to what you can write there. Importance of directive principles. Article 37 states that directive principles are not enforceable. Directive principles are not enforceable in a court of law. In a court of law. Nevertheless, they are fundamental in the governance of the country. They are fundamental in the governance of the country. According to Dr. Ambedkar, any government that is responsible to the people, any government that is responsible to the people cannot ignore the directive principles. Directive principles. If the government ignores it, it will be answerable to the people. Ignores it, it will be answerable to the people in the next elections. Directive principles are the best election manifesto. Directive principles are the best election manifesto that any political party can have. That any political party can have. The directive principles may lack. Directive principles may lack a legal sanction, but they enjoy political sanction. They enjoy political sanction. They act as a lighthouse which reminds the government. They act as a lighthouse which reminds the government about its responsibilities. About its responsibilities of achieving welfare goals. Of achieving welfare goals. Former Chief Justice of, next paragraph you can write. Former Chief Justice of India, Justice Kania, has remarked, Justice Kania, K-A-N-I-A, Kania, has remarked that inclusion of directive principles does not reflect the will of the majority of the Constituent Assembly. The will of the majority of the Constituent Assembly, but it can be considered as the wisdom of the people. Wisdom of the people reflected through the Constituent Assembly. They have not been given legal enforceability. They have not been given legal enforceability, not because they are inferior to fundamental rights, or any other part of the Constitution, but because they are positive obligations of the state, and their implementation demands resource and time at the disposal of the government. They are as important as, the last line, they are as important as any part of the constitution. Any part of the constitution. With this, we end our discussion on directive principles. So tomorrow when we meet, we start with first fundamental duties. I am not going to discuss fundamental duties. I am just going to discuss the nature of fundamental duties. So I am going to discuss the nature of fundamental duties, and then we move to the next part, that is the union executive. So tomorrow I am also going to start with our discussion on the office of the president. Thank you.